Hi, my name is Brad Micklin. I'm an attorney and managing member of the Micklin Law Group, which is a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. There are often many mistakes that men will make when handling a divorce action. First is to do it themselves. I always say cheap is never cheap. If you think it's better to do it without an attorney, you're making a mistake. The problem isn't necessarily what's going to happen or how the process works, but what you don't know. You need to understand at least what the areas of law are. You need to understand what the ranges of outcomes will be, and you need to know what the risks are. And there's no way a person without a legal background can do that without the help of an attorney. The second mistake I find men often make in a divorce action is believing that they can handle it. Men, especially if they're successful, believe that if they handle the divorce the same way that they handle their life and financial decisions, that they'll be able to handle it. And they're making decisions often in a good economy, their business is going well, so they believe they can handle it. They're not thinking about future changes in circumstances. They're not thinking about what happens if they lose their job, or they become disabled, or the economy turns and their business tanks. So many will enter into support obligations and distribution obligations without contemplating how that may change in the future and how they may need to get relief from the court or those payments. Another mistake men often make is they don't read a settlement agreement carefully. It's often very long, it's often very technical, and they will often believe that they understand what they're agreeing to. But without understanding the specific terms, how they affect you, how they may change in the future, you're not going to understand your obligations. It's going to make it hard to comply with them, and it's going to make it very challenging to modify them if things change in the future. Lastly, I find a lot of men agree to permanent alimony without realizing that they don't need to. A lot of people go into family court and divorces, even a lot of lawyers and judges, believing that simply because a marriage was of long duration, like 15 or 20 years, and there's a big discrepancy in income, they believe it's permanent alimony. The laws were changed years ago because this prevalent belief was inaccurate. It's more important to understand what your spouse's needs are when determining how long and how much to pay for alimony. It's not just a question of duration of your marriage and income discrepancy. Other factors that you should look at: the lifestyle that you shared during your marriage, your ability to pay in the future, the other spouse's ability to earn, as well as the duration of your marriage and income discrepancy. Additionally, there's a statute that outlines nearly 13 factors, including the 4 I just named, that you should also be familiar with and consider before agreeing to any term of alimony. Another mistake men often make is agreeing to alimony without agreeing or contemplating how it may need to be modified or altered in the future. Statute has certain language in New Jersey that says under what circumstances alimony can be modified or terminated, but you're not bound by that. You can make any agreement if you're settling your case to when it gets reviewed and to when it gets modified or terminated. You don't need to rely on the statute, but you should have it spelled out specifically so you know what to expect and how to prepare for the future. If you'd like more information on any of these topics, you can go to our website at micklinlawgroup.com.